told David Topor coming in, I'm 62, but feel like I'm 92. My knee, my back, everything hurts. But anyway, I just want to, planning for your future is about more than just enjoying retirement, okay? And we just need to be prepared for the expected and unexpected, ensuring that both you and your family are protected. And that's what this presentation is about today. We always have this presentation every year. You'll be surprised, my parents included, who do not either have a will, a trust, or powers of attorney in place, or even an advance directive when they become impaired and we don't know their wishes. So this is probably one of the most important presentations that we have each year.
All right, so this presentation is to help you create peace of mind for your tomorrow. And again, my name is Courtney Scollard. I'm an estate planning attorney. And then the second half will be David Topor, the financial advisor. I went to UT College of Law and graduated in 2009. And since about 2015, I have been practicing in estate planning. So I've got a few years under my belt now. And the model that I use for my practice is concierge estate planning. That means I don't have a brick and mortar office. I work out of my home, and I come to you or meet in a mutually convenient location. Usually you're going to have all your documents and things like that at home, so I don't like to come and meet you in your home, or again, meet at like a coffee shop, anything like that, to get things started. We do have a legal disclaimer because this is being recorded and will be available later on. You can take a look at that disclaimer. If you're watching the recording, please read this, but basically it just says this presentation is general information and educational purposes only. It does not create an attorney-client relationship or a financial advisor-client relationship. It's not legal advice, it's legal education and financial education. So myself, Courtney Scollard, David Topor, and the Blount County Community Action Agency are not liable or responsible for any actions that you do or don't take based on this information. All right, real quick, the presentation goals. Why are we here today? We're going to go over information on the legal documents that you need to make financial and healthcare wishes known, ways to protect your assets, ways to plan for long-term healthcare, the different types of estate plans, and we'll discuss the differences between wills versus trusts. Quick little roadmap here. I like to go in the order that a document is typically needed. So we'll start with powers of attorney, nomination of conservator, advance directives, and then we'll get into the estate plans, wills, trusts, DIY, that kind of thing. All right, and so the first thing is to always make sure that we all understand that the words mean the same thing. So a couple quick definitions. What is estate planning? It's the process by which an individual or a family arranges the transfer of your assets upon death. An estate, and this is the legal term, is the total property, real, which is land, and personal, not land, anything else, owned by an individual prior to distribution through a trust or a will. So after you die, all your stuff is called the estate. A power of attorney is a legal document that gives another person the authority to act on your behalf as if they were you. And then probate is a court process. Probate only applies if you've gone through the court process to establish the validity of a will or other document, and gives authority for a living individual to settle the estate, the stuff, of the deceased individual. Alright, so families come in all kinds of flavors. I like to think of it as Baskin-Robbins, 31 flavors of ice cream. The law assumes that a family is going to be a man, a woman, married, they have 2.5 children, who then each marry and have their own 2.5 children, so on and so on. But we all know that not every family fits that mold. We've got individuals who never get married. So the law is going to assume you have a spouse. If you don't have a spouse, what do you do? We've got individuals who get divorced. We have blended families. We have families that are married but don't have kids to pass on their estate to. We've got the flip side of that, families that have kids but have never gotten married. Oftentimes you'll see people who are raising someone else's kids, be it nieces or nephews, be it non-family but close friend, that kind of thing, or even foster care. then even if your family does fit the mold, people never seem to die in the right order. You may have children who predecease their parents, or you may have a caregiver, the healthy spouse, who dies before the sick spouse. So no matter where you fit in what kind of family, what flavor your family is, it's important to have at least some of these, if not all of these, documents in place. All right, so the first document that I'm going to recommend is a power of attorney. This is an agreement between two parties, you, the principal, and your attorney in fact. And the document gives your attorney in fact, or your power of attorney, the rights to act in your place. When can it be used? It can be used while you're alive, because you're giving someone else the authority to do what you could otherwise do. Once you're dead, you can't sign a contract. That's kind of where that falls. So a power of attorney dies with the person, is what I like to say. But it can give all kinds of authority to someone while you are living. It can be in effect in case you become disabled and can't sign contracts or make those decisions on your own. It can be in place for if you're traveling out of the country. There's all kinds of different powers of attorney. There's health and there's financial. We'll talk about both of those. A power of attorney can be durable. It stays in effect even if you become disabled or incompetent. It can be springing. It doesn't start yet, but if an event happens, so if I become disabled or incompetent, then it goes into effect. Or if I leave the country, then this would go into effect. There are some powers of attorney that are limited. If you've bought a house or bought a car, you probably signed a limited power of attorney so that the car dealership could apply for your license plate. It gave them a very limited scope of what they could do, but it did set up, that power that someone else could act on your behalf. And then there's other types of powers of attorney. Certain organizations require their own specific forms, like Social Security, the VA, things like that. So a conservatorship is when a court determines that an individual, an adult, is no longer competent to manage their own affairs due to either mental capacity, age, or physical disability, and sometimes a combination of those. So Tennessee allows for conservatorship over the person, the property, or both, but it is a court process similar to probate where essentially someone else can go to court and say, hey, mom no longer makes good decisions, she's a risk to herself, or dad just physically cannot take care of himself, someone else needs to make these decisions. So it's essentially legally reverting from being an adult back to being a child, because when you're a child, your parents or guardians are legally responsible for you. So in a conservatorship, a conservator becomes legally and financially responsible for you, for your decisions. This is something that you can decide ahead of time and do what's called a nomination of conservatorship, where you can pick, if I reach that point where someone else is going to be legally and financially responsible for all my decisions, who do I want it to be? And you can do that while you're of sound mind. So especially if things like Alzheimer's and dementia run in your family and you think that might be a possibility, then I always do recommend setting up a nomination of conservatorship. Again, it's just a short document that then your family could take to the court for a conservatorship and say, hey, when mom or dad were of sound mind, they said this is who they wanted to be their conservator, their guardian. In 2017, the Tennessee Board of Licensing Healthcare Facilities combined what's called a living will, which is your decisions, and the medical power of attorney. Again, power of attorney document that puts someone else, in the decision-making position. Combine them into one document called the Tennessee Advanced Directive for Healthcare. You can go to the tn.gov website and get these for free. So there's really no reason not to have an advanced directive. Now what it does, it's a written document that sets out your preferences about treatment should you become incompetent or unable to communicate these preferences to medical personnel. I refer to the advanced directive as a worst case scenario, like last wishes. Not last wishes as in where you want to be buried, what kind of funeral you want to have, but your last wishes for your health care. These aren't gonna be like you go in for rotator cuff surgery, and you know, something happens, they're gonna treat you. This is more like, you know, you're in a coma and that kind of thing. Who do you want making the decision and what treatment do you want? But it gives you the opportunity to think about what you would consider to be an acceptable or unacceptable quality of life, and what kinds of treatment you do or don't want if you reach that point. And I think this is one of the kindest documents that anybody can create, just because it takes that burden off of your family. Nobody wants to be deciding, does mom want to be unplugged or not? Does dad want tube feeding or not want tube feeding? You know, would he be okay with living with this? You know, once your family member reaches that point, it's so hard to try and imagine like what they would want, but this document puts it out there. And so it just allows you to go ahead and make those decisions, communicate it to your family members so that they don't have to have that burden on them later on. And you don't wind up with some sort of treatment that you didn't want. So far, we have talked about documents that are used while you're alive. Power of attorney can only be used as long as you're alive. Nomination of conservatorship, you're still alive. Advance directive, you're still alive. The rest of the estate planning is going to deal with what happens after you die. Because unlike the power of attorney, which is only effective while you're alive, a will is only effective after you die. You can change it as many times as you want before that. All right, there are 3 general types of estate plans. There's going to be no plan. If you don't have a plan, you're like, I haven't done any of these documents, don't worry. The state has a plan for you. We'll talk about that. And then there's also some like DIY options on things that you can do on your own to help direct what's going to happen with your estate. Then there's the traditional wills. Last will and testament has to go through probate, no effect until you've passed, that kind of thing. And then we have trusts, which are kind of a hybrid, because trusts can be used while you're alive, but then they also deal with how your estate is going to be passed on after you die. So no plan, also known as the state plan. If you don't have a will, or any other directions written out, you're what's called an intestate estate. And so Tennessee has what intestate succession. Your family will most likely have to go through probate to distribute your assets because they have to get someone appointed to actually sign off on all these things. And this is it's called the table of consanguinity, the bloodline. And so here we've got kind of the way that it goes, but essentially it's going to go down your line. If you run out of people down the line, it goes out and then down those lines, so siblings and things like that, and down their lines. You run out of that, you're going to go up to your parents and out and down. It keeps going. It can get really complicated. So if nothing else, it's great to have a simple will that says, you know, who's going to get your stuff, so that your executor isn't looking at this trying to map out your entire genealogy so that they know who actually can get your stuff. So other options without a will or other documents, DIY. Payable on death designations. Now, Tennessee does not allow a transfer on death, so this does not apply to real estate, to land. But you can do things like bank accounts. That's the biggest one I know of, bank accounts. You can do beneficiaries on financial products, which is going to be similar to that, life insurance, annuities, IRAs, things like that. Those operate by contract law. When you get that life insurance, you sign and you say, this is who my beneficiary is. When I die, they get this money. Never has to go through probate, as long as you have a named person. And then there's joint tenancy. This one does apply to land. Can also apply to things like vehicles, bank accounts, all kinds of stuff. But that's where you're not the only person on the title. So if you are married and you and your spouse bought land together, then you're both on the title. If you were married when you bought it in Tennessee, it's called tenancy by the entirety, and there's automatic survivorship. So Bob and Sue are married, they buy a piece of land, Bob dies, Sue automatically owns 100%. Sometimes people will add their children. They may have siblings who are also on titles, you know. And again, that can be real property, vehicles, banks, anything that has title. Now, there is a danger, or a warning that I'll give with that adding someone else to the title of whatever your asset is does open you up to any of their liabilities, because they are an owner of whatever that asset is as well. Especially with land, could be subject to things like gift taxes or capital gains taxes. That's where it's important to speak with an accountant and a financial advisor on all of that. And then there's also control issues. Let's say you add your child to your property so that it'll automatically go to them. Well, let's say now you need to sell it and you want to move into a condo. Well, you have to sign off on that, but so does your kid. And so if you're on the same page, great. If you're not, that could create some issues. Last will and testament. This is the most common form, or most commonly known form of estate planning. So a will is a legal document, and it has legal requirements that the state of Tennessee has set out that have to be included. But it can go outside of what the intestate plan has. So in that one, it's going to be like bloodline only. Your last will and testament, you're writing the document, and so you can go outside of that. You can include non-family members, friends, charities, things like that. You can also exclude people who would normally be involved as part of your estate. So someone who is part of your bloodline, but you don't want them to get anything. Estranged family members who maybe have either some sort of addiction or gambling problem, but also individuals who are disabled and receive Social Security income. Receiving a large inheritance could jeopardize their Social Security income and their insurance. And so, if you have anyone in your family who is disabled, you want to make sure that you're not going to create a problem for them by leaving part of your estate to them. Like I said, there's all kinds of rules and requirements that the state has for a will to be valid. So even if you think you can write your own will, it is good to talk to an attorney to make sure that all of those boxes are checked, because if they're not all checked, it's not a valid will. So, if you have a will, again, it does not go into effect until you die, and then once you die, it has to go through probate in order to validate your will, officially appoint someone as your executor or personal representative. They get what are called letters testamentary from the court. It's signed off by the local probate judge, and then they have the authority to distribute your assets to your heirs, clear any title issues, settle your debts, things like that. So here in Tennessee, a full probate there's three kinds. There's full probate, which is going to be real estate and assets over $50,000. Or actually, if you have any amount of real property and asset, it has to go through the full probate process. If you don't have any land, you can potentially do a small estate if the entire value is under $50,000. If you only have land and no other assets, everything else has been taken care of through beneficiaries and things like that. The only thing you have is, a plot of land. Then that can go through a process called muniment of title. But that literally means you can't even have like $10 in the bank to deal with. It can only be real estate. So when you go through probate, typically it's a 1 to 2 year process if it's easy, if there's no hiccups. The fees, it's estimated that 4 to 10% of your gross estate will be consumed up by the probate cost between court costs, attorney fees, accountant fees, all those kinds of things. Here in Blount County, the filing fee to open probate is going to be, $431.40. That went up this year. So that's something that can change each year depending on what the commissioners vote for, plus attorney fees. And probate has to be opened in every county that you have land. So let's say you inherited, the family farm out in Rutherford County, but you live here in Blount County. Well, you get to open 2 probates because you're going to have to go through every county where you have that land. Let's throw in a beach house in Florida. Then you've got an out-of-state probate to throw in. Another thing about probate is it is public record. Anyone can go down to the courthouse and request to see a probate file. If you guys are bored after this, you can go down to the courthouse and you can say, hey, I'd like to look at probate files. And you can read somebody else's will. So, the option that David and I both really like, and applies to most people, honestly, is going to be trusts. It's a hybrid option. It can be used while you're alive and after you pass. So the easiest explanation of a trust is it's like a bucket. So a trust is a legal document. It's written down, you get a big old binder, that appoints certain people to certain roles, gives instructions. So you have the trust is the bucket. You have your trustor or grantor, that's going to be you. You're the person who gets the bucket. Your trustee is the person who's carrying out your instructions, holding on to the bucket. Initially, you can be the trustee of your trust, depending on the type that you have. A revocable living trust, you can be the trustee. You're still in full control. But in that document, you also go ahead and appoint a successor trustee who's going to step in when you're no longer able to. You've got your trust property. That's all the things that you put into your bucket. Your home, your bank account, your business, your family heirloom jewelry, your beach house in Florida, all your things. Anything that is in that bucket, in the trust, is governed by your instructions. And so in the trust, you can write out instructions for while you're alive. The revocable living trust that we typically use basically says that you're in full control while you're alive. You can use your assets however you want. But then it has those instructions for after you die, what you would typically find in a will. But we're able to make it much more customized for like timelines and things like that. And then you also designate your beneficiaries, who's going to benefit from the trust. Again, you're a lifetime beneficiary, you get full use and benefit of all of your assets that are in the trust. And then your beneficiaries, your successor beneficiaries, who you want to leave those assets to. So here's just kind of a quick breakdown of wills versus trusts. It is in your packet, so I'm not going to go through like all of it, but basically it's that a will is going to have to go through probate, so the courts are going to be involved. It's going to take 1 to 2 years, and before you can even open probate, you've got to have the death certificate and an application to probate, so chances are it's going to be at least a month after the person has passed away before you can even open probate and have an executor appointed to access the bank accounts to take care of the final expenses of the person who's passed away. Again, it's public, it can be expensive. Because it's public, it can easily be contested. You'll have a court date where it gets published in the newspaper and everything and says, hey, if anybody has a claim against this estate, come show up. Whereas a living trust does not have court control. You don't have to go through probate if it's properly funded. There's no delay because you've already appointed who your successor trustee is. The moment you pass away or just become incapacitated, your successor trustee can pick up that bucket and just carry right on with whatever they need to do. You can appoint your guardians and conservators within that document. It protects you during your lifetime, and there's no contest clause. So there's very limited cases in which somebody could come back and say that you were totally incompetent when you created the trust. But aside from that, they can't contest that they were left out or they got a different asset than they thought they were going to get, that kind of thing. And it's totally private when it comes to the instructions that are in your trust. Only your trustee and then your beneficiaries get to know what is in your trust. Like I said, almost everyone could benefit from a revocable living trust because of the privacy. It avoids probate. It's revocable, so you can change it at any point in time in your life. And you have the ability to preserve the estate tax exemption for the first spouse to die. So that's a definite benefit. Not all living trusts or estate plans are created equally. I gave that example of the trust being like a bucket. Well, just like with a bucket, you can do, you get what you pay for sometimes. DIY is like going to the Dollar Tree, picking up a plastic bucket to take down to the beach. It might work for a day. It might not. You get what you pay for on that. It depends on how savvy you are and what research you've done. So it's all dependent on you for DIY. You can do a trust mill. You're going to get, it's literally just like a fill in the blank kind of trust. If everybody got one today from that, they would all look exactly the same except it would have different names. You can go to an inexperienced attorney using generic documents. So maybe you've got a nephew who does criminal law. Excellent. He probably doesn't know much about estate planning. Those attorneys, they may be like, okay, cool, I can help you with this, but they don't know all the ins and outs. So what David and I offer is collaboration between an experienced attorney and a financial planner. Because your estate is going to involve legal documents and money. I mean, so we each try to stay in our own lane. You don't want to take financial advice from me, but you do want to take legal advice from me. And so I will help you to get your documents set up, and then David will help you to fund your trust. So I'm going to turn it over to him.
So when you fund the trust, okay, the trust is only going to protect the assets that are funded into the trust, okay? A lot of trusts that are common now, and we didn't mention it too much, but it's called an intestate trust, which means it doesn't come into effect until after you die. And so then at that point, the will puts everything into the trust. Well, wait a minute, we got a trust so we can avoid probate. We can avoid that whole process. So we've done a lot of reviews where it's is it called intestate?
Testamentary.
Testamentary trust. Testamentary trust, meaning that the trust is there and the assets go in through the process of probate, which is crazy. And so some people, maybe someone in this room, has one of those and doesn't know any different. And so a lot of times one of the things we do is sit down, and if you've got documents and you haven't reviewed them in a while, then we invite you to come in and we can do that for you. Or the other thing is out of state. Okay, if you set up documents from another state and you move to Tennessee, guess what? That's going to delay the probate process, because all of a sudden the lawyer who knows all about Tennessee law doesn't know about Michigan law. And so it's like, wait a minute, we got to make sure that this jives with Michigan law, okay? So if you've a new arrival to Tennessee and you haven't updated your wills from previous states, that's another reason that you want to talk to an attorney and make sure that everything you have is going to work, okay? We've seen trusts where it says the trust is funded with $10. What in the world does that mean? That means a trust has no power unless it's protecting something. So the lawyer just put that in there, and a lot of times the lawyer signs it, you get the notary to sign it, they give it to you and say, here's your trust. And then you don't know what to do with it, because you're like, okay, I got a trust, good, I can check that off the box. And all of a sudden you don't realize that, no, now you got to start to retitle and put stuff into the trust, because the trust only works for what's in it, okay? And the other thing that's really important about trusts that I don't think enough people talk about is trusts are the best way to inherit money, okay? Because when the money stays in the trust and you got a beneficiary here, okay, more often than not, it can protect you from a bad marriage, addiction, certain creditors can't come. As long as the money stays inside the trust, it's nobody's business, okay? So if your kids are disciplined enough to keep the money in the trust, then while the money's in the trust, even though they're the beneficiary, either they can grab in and take some of the money, okay, as long as it stays in the trust accounts, nobody can touch it, nobody can see it, it's nobody's business, okay? So that's why it's the best way to inherit money. So if you've got those kind of concerns, those are other situations that are important. Okay, so what kind of financial accounts are used? First thing I do typically is I tell people, go open a bank account in the name of the trust, go find a free account, put $100 in it, okay? Whether you use it now or whether it's going to collect assets down the road, get it over with, okay? Because that's the tool that the trustees are going to use, okay? You can put non-qualified annuities, tax-free death claims from life insurance policies, non-qualified brokerage accounts, those types of things. Either you can retitle from your existence. Let's say you have a Charles Schwab investment account, that's fine. You can talk to them. More often than not, they're going to want to have you open up a new one in the name of the trust and transfer stuff over. A lot of times financial institutions aren't going to want to rename it. Okay, it's tough for them to do that. They're going to want you to open up a new one and transfer the funds in. Okay, that's fine. But there's a process and it takes some time. A lot of times you can do the payable on death. a lot of times we see that, payable to my trust, okay? Some banks and institutions have an issue with that, and what you don't want to have happen is problems for your heirs when it's time for them to execute all this. So the more you can get done and into the trust, the better your plan is going to work when you need it to work, okay? Because think about it, when they're dealing with your death, okay, there's a lot of emotional stuff. You don't want to add any other kind of burdens as far as stress or problems or, you know, why did she leave me this mess? You know, if you can make it easy for them, they will really, really, really appreciate it. Okay, you got to retitle real estate assets. A lot of people don't do that. They don't know how to do that. They don't understand the reason why to do that. You got to be careful. A lot of times we find problems with the title. Sometimes, you know, dad and mom lived together. Dad died, okay? Mom lived there. Never thought that she needed to go probate the house and put it from dad's name, who died, into her name. Okay, then all of a sudden we go to put the title of the house in mom's, that should be in mom's name, but it's still in dad's name. Okay, you got to probate that, right? That's why they have that other special probate thing, because you can do that. So there's all sorts of messes that we can uncover in the process of funding it. Okay, and then you can reassign tangible assets. That's a simple piece of paper that just says, hey, I own this, and anything that's in my house that I have that's within these four walls goes in. So then we have to worry about, you know, naming things specifically. Okay, now once it's in the trust, then you can say, okay, what do we want to do with mom's teacup collection? Well, guess what? You know, daughter number 3 really wants that. And so you can there's a provision, those are called bequests, okay? But you can only bequest something that's in there. So it's kind of interesting how that works. You know, I'm going to share a story, because sometimes we can learn by other people's problems. There was we were talking through, because we go to a lot of conferences, and there was a person who had a huge estate, right? And there was 3 kids, and the kids didn't fight about any of the money. You know what they fought about? They fought about the hand-hewn butcher block that Grandpa made for Grandma, and Grandma promised both daughters the hand-hewn, yeah. And so they're probably bitter at each other to this day because of, he should have just made 2 butcher blocks, as far as I'm concerned. But he didn't. He only made 1, and so you have to figure out what you do. And so bequests are really, really important. And so sometimes that's more important than the dollars, because that's the sentimental. You know, all right, so ways to fund the trust. So proceeds from life insurance is probably the most efficient way to do it. Life insurance is real easy. You pass away, you get the money comes in. Now, you got to be careful. The new law, the big bad beautiful bill, or the big beautiful bill, big bad wolf, I don't even know what it's called. But it raised the exemption for estate planning locked it in at $14 million, which is awesome for most of us, because we don't have to worry about it. In Tennessee especially, because we don't have a state estate tax. But sometimes for some people, life insurance proceeds might put them over the top. So you gotta be careful. So if that's the lane that you're living in, good for you, but just remember, if you've got $12 million that you're going to be passing on, and you got a $2 million life insurance policy, that $2 million will factor into the size of your estate, and anything over that exemption will be taxed at 40%. So in this particular case, if you had 13 million, you have a 2 million, that's $1 million over, that's 300,000 that's going to the government. Okay, and some states like Maryland have both an inheritance and an inheritor tax. So if you're nice enough to get something from your parents, you're going to be taxed on it in Maryland. Tennessee doesn't have any of that nonsense, so that's good. But you just have to know, and that's why dealing with people who have this, information is critical, because we bring our knowledge and expertise to you. Gifts of family members is a way to do it. So we set up a lot of irrevocable special needs trusts, because grandparents want to give to their grandson who's got, let's say, cerebral palsy or is on the spectrum of autism and knows they're not going to be able to do it, but they want to be able to do that. And so we can use the gift tax exemption. We can do a carve out of that inheritance in a way. So that's one way that a lot of people can do that. So if you have special needs children or special needs grandkids, definitely have a conversation with them. We have a lot of experience doing that, and that's a huge benefit. Transferring funds from existing accounts, that's pretty much speaks for itself. Quick claim deed on property, that's something the attorney does. And then a letter of assignment for tangible property. So some of the other special stuff, irrevocable life insurance trust, that's top on my mind because I just sat through a 6-hour training for my CE on that. Yeah, there are so many complications to that. But again, that has everything to do with if you want to protect your exemption there with life insurance. Plus, it just is a great way to protect the next generation moving forwards. Special needs trucks, I can't speak enough about those. Those are huge, especially for kids that have all sorts of issues, and you don't want them to lose their benefit from the state, because the states can be very generous, and if there's a windfall, they won't care. They'll just be like, you have too much money, you don't qualify, and then they gotta redo stuff, and then you're introducing look-back periods. It gets to be crazy. There's the Miller Trust, which deals with helping people who are really close to Medicare and Medicaid. Final Expense Trust, Tennessee allows a funeral trust, $6,000, so if people need to shelter assets from consideration, you can do that. And then Medicare compliance SPIAs, where you turn an asset like an IRA into a payment stream that continues on but keeps you below the threshold. So there are some products out there, and you got to speak to people who've got experience so you don't lose out on benefits, because that's huge. The taxes, how taxes are treated, it's a compressed tax schedule. So it went from 5 to 3 tiers this year. You can see where the threshold is, 24% tax. For individuals, it's upwards of, $60,000, $70,000, right? For a trust, it's not. It's super compressed. So you got to be very careful what kind of accounts you put in there, what mechanisms you use when you do have a trust in there. This would be for an irrevocable trust, not for a revocable trust. So if you have a revocable trust and you have assets in it, it's taxed at the grantor's tax rate. So that's one of the benefits. We were talking about how you can benefit from it. This would be after you pass away and it becomes locked in. Okay, that's the nice thing about the irrevocability of a trust. When the first spouse dies, you can't change it. Okay, because think about it. If you had, a husband and wife, and the husband passes and the wife and the husband had 2 from a previous marriage, their interests are going to be protected. If you didn't have a trust, she could change her will and completely disinherit them from their father's wishes. But with the trust, that can't happen. So that's a main reason why we see a lot of people coming in with what's called blended families. Okay, and then long-term capital gains. So please consult a tax advisor when you're dealing with that. We're aware of it, but you got to be careful how you do it. And you will have to set up if you had an irrevocable trust for a special needs person, that would be anything that grows in that account would qualify for this. Tax treatment, and it would have to get their own tax return each and every year. Okay. Then we're going to inventory your savings, your investment. We're going to take a look and see what can go where and how best to do that. We're going to review options to transfer non-qualified in, whether or not that makes sense, whether that's in your financial best interest. We'll talk about that. We're going to open up a free checking account somewhere, and deposit and order checkbooks. And then we're going to make sure to transfer the property. That's where she kind of picks up the ball. We make sure that that deed can go in. So once that's done, pretty much, we're looking at making sense. Okay. Then we take with step 2, which is we're going to change beneficiary forms on the life and the non-qualified contracts that you have to make sure that there's synergy between the contracts you have out here and the trust that you just established. Okay? And so we have to make sure that everything's going to work and kind of flow in the same direction. Okay? If life insurance is going to be directed instead of to the kids individually, but to and through the trust, because you like that control, then you can go ahead and do that. Okay? It's important that we align the IRAs and the trust. So one thing about IRAs is IRAs are individual retirement accounts. So IRAs cannot go into a trust unless you're willing to, pay all the taxes that are due. Okay? So typically your IRA is going to be held outside of and independent of the trust. And so we want to make sure that we do that. Okay, so that's important. It's a distinction. Okay, same thing with pensions. Okay, so here's another thing that we have to make sure is your beneficiaries should align on everything, because if your first wife is still on your pension when you die, even though you've been married 3 more times and you've had 6 wills drawn up, guess who's getting your pension when you die? Your first wife, or first ex-wife, or whatever you want to call it at this point. I don't know. So you have to make sure, and that has been tested just about in every state. Where I signed this will, I signed this trust. Doesn't matter. Contract law takes precedent. So I make sure people dig out all those insurance policies, look at those pensions, look at those, 401k and IRAs, beneficiary designation, because that's where it can really get ugly. Okay. Then we look at life insurance to find out what the potential risk could be. Are you qualified for it? Is that a great way to do it? Some people are like those options as well. The other thing I do is put together a written financial plan that because when the trustee gets this big bag of money, they don't know what's going on. Maybe it's the first time they've ever had to deal with this, and then all of a sudden they're like, wait a minute, I'm kind of coming into this, I don't know what's going on. Because a lot of times we don't share what's going on with our finances with our kids. Some people say, that I've heard this all the time, if they knew what I had, all they'd be doing is coming and asking me for this, right? So a lot of people keep it close to the vest, and that's okay. That's kind of what we have for you today. I think that's kind of